Check 1, 2, check. Check 1, 2, check. Testing 1, 2.
Okay, good afternoon, everyone, faculty, students, staff, alumni, community guests. Welcome to the University of Pittsburgh School of Law for our annual Constitution Day lecture. It is quite fitting that we're here today on September 17th, the very day, 1787, that 39 delegates, there were 55 of them there that day, but 39 of them signed the document, the Constitution, that established the framework of our republic here today. And today, this is a federally recognized day as both Constitution Day and Citizenship Day. And the history of these two celebrations I'll just talk about here briefly. I'm a constitutional law professor and I love history, so I'm going to sort of note this. These two merged together years ago. While there was a sort of a grassroots movement to observe the Constitution signing and the date, there was also another movement that happened in the 1930s, which led to the creation of I Am an American Day. And that was to honor new citizens. Then in 1952, President Harry Truman formally sort of linked these two days together and these two ideas, the Citizenship Day and Constitution Day, to September 17th, recognizing our rights, rights and responsibilities that flow directly from our Constitution, all right? And then finally, in 2004, Congress not only combined the holidays, but also established, all right, the very reason why we're here today. Federal law does require that every educational institution receiving federal funds hold an annual program like the one that we're doing today for Constitution Day, right? And this mandate is of course, it's important. The mandate for educational reflection is particularly resonant for all of us today. Today's event, even when we hear from our distinguished scholar, reminds us that our nation was founded on two basic principles. One, of course, being that we are a government of laws, not individuals. I'll say it again. We are a government of laws and not individuals. And two, that our three branches of government possess separate and distinct powers. They sometimes share those powers, but separate and distinct powers that function as checks and balances in our system. And for us as lawyers, as students, as future lawyers, of course, the responsibilities of citizenship take on the weight of a professional duty to serve as stewards of that constitutional structure and guardians of the rule of law. And this year, our reflection is guided by one of the nation's foremost legal scholars. We are here to explore the vital topic of lessons learned about the rule of law from the Trump administration, and I can think of no better person who is equipped to lead this discussion than our distinguished speaker here today. And I look forward to these comments. It promises to analyze the consequences, all right, of recent events around the rule of law in America and in moving forward. So before our speaker comes up today, I do want to introduce to you and offer a warm welcome to our distinguished Professor Greer Donnelly, the Associate Dean of Research and Faculty Development and Professor of Law, who has coordinated and organized this day for us today. She is going to introduce our wonderful speaker here today. So thank you.
Thank you. Hi, everyone. Thank you so much for coming today. I have a few housekeeping notes. First, there is going to be lunch served after the lecture, just right outside. Second, I know many students have class at 12:40, so I expect that there will probably be a mass exodus around that time. This is not a planned protest. So just so you know, that's going to happen. If you do have to leave early, I ask you to be quiet and try to be discreet, particularly when you're getting lunch outside, so we don't want to disturb the lecture. With that out of the way, I'm thrilled to be able to introduce our Constitution Day speaker this year, Brian Tamahana. Professor Tamahana is the John S. Lehmann University Professor at Washington University School of Law in St. Louis. He is a renowned jurisprudence and law and society scholar. He's the author of 10 books and over 75 law review articles and book chapters. His books have been translated into 12 languages. They've been the subject of multiple published law review symposia. 4 have even won international prestigious awards. In 2013, he was voted the most influential legal educator after writing a book critiquing the legal academy. He has been a public defender, an assistant attorney general in Micronesia. I learned just now, a former dean, and I learned last night that he was also a surf bum. So we are especially lucky to have him here today to talk about the rule of law. So please join me in welcoming Professor Tamahana.
Thank you for those kind introductions. I'm really honored to be here today to deliver your Constitution Day speech. I'm going to move quickly because I know time is short. So upholding the rule of law has long been a commitment across the American political spectrum. Where government of law is not men, founder John Adams famously stated. The multifaceted array of actions taken by the Trump administration since his return to the presidency constitutes the greatest challenge to the rule of law in American generations because it aggressively applies extreme pressure on legal restraints across the full gamut of governmental activities and institutions. In this lecture, I'll step back from the situation to see what lessons can be drawn from this unprecedented rule of law stress test. Although what I say will come across as highly critical, it's not my immediate purpose to criticize these actions. There are many such criticisms already. My purpose instead is to glean broader insights about the rule of law from these actions. Viewed from the standpoint of a legal theorist who's studied the rule of law for over 2 decades, these actions provide a unique opportunity to identify potentially fragile joints and how the rule of law can be evaded or undermined. While some of these vulnerabilities are well known, others are seldom recognized or highlighted. I'm trying to bring out things about the rule of law that have so far gone under the radar. My lecture will examine 3 points. The critical starting point is the importance of truth and facts. The second is the impact of pretextual arguments. The third is the consequences of flooding the zone with actions in a way that takes advantage of time differences in the way executives and courts function. These 3 points will be discussed against the backdrop of a 4th point, which is extreme pressure now currently being placed on the judicial branch. After setting out these aspects of the rule of law, I'll outline these 4 points and how they come together. Now, before proceeding, let me acknowledge up front that my political views are left of center. Concerns about the Trump administration expressed by progressives are frequently dismissed by his supporters as false political ideology or manifestations of Trump derangement syndrome. In an effort to allay these concerns, I purposely will build much of my argument on the statements of Republicans and conservatives themselves, who support certain political aspects of the Trump administration, nonetheless are opponents for these reasons, and their expressed concerns about Trump that I'll describe to you cannot be dismissed as leftist politics. Okay, so let me first say a few things about the rule of law. It's often said that the rule of law is an essentially contested concept, and that's true, but it's also true that there are certain core points about the rule of law that are widely agreed upon. So those are the points that I'm going to focus on. The first is that everyone would agree that the rule of law exists when government officials and citizens are bound by the law. Now, a more concise way of saying this is that the rule of law exists when everyone's bound by the law. However, I've specifically mentioned government officials to highlight that the traditional thrust of the rule of law has emphasized legal restraints on government actions. This has 2 angles. The government must have affirmative legal authorization for its actions and must not violate legal restrictions. Second, it's widely agreed upon that the rule of law requires that law be set forth publicly in advance so that everyone has notice of what it requires. And the law must be applied equally to everyone, no matter who they might be, rich or poor, friend or foe. Third, there's broad agreement on 2 main purposes or functions of the rule of law, which work in different ways. One primary function of the rule of law is to protect against government tyranny by restraining the arbitrary exercise of power by government officials. This entails, as I just mentioned, that the government actions be legally authorized and comply with legal restrictions. Binding government officials to law in these ways protects citizens from tyranny by preventing ad hoc actions based on an individual whim, prejudice, anger, favoritism, greed, personal interests, and so forth. The second primary function of the rule of law is to enhance individual liberty. The requirement that laws must be set forth in advance gives everyone notice, as well as predictability about what they can and cannot do. This enhances liberty because we know what we're free to do without government interference or sanctions. So that is, specifically, we can do whatever the law does not prohibit. And it enhances liberty because we can anticipate the legal consequences of our actions, thereby enabling us to plan ahead. And this is not just about criminal prohibitions. It applies to everything, our interaction with one another. For example, in entering a business contract or a lease, understanding what the implications of that will be should things go wrong. A 4th aspect of broad agreement I'll mention is that the rule of law cannot function without an independent judiciary that is committed to applying the law and holding government officials to operate within the law. One of the deepest puzzles for bringing about the rule of law is that the government is the authority that creates the law. So how can the government that creates the law be legally bound? Thomas Hobbes skeptically remarked that the sovereign cannot be bound by the law, since nothing has the power to hold the sovereign to comply. And the sovereign can always change its mind and decide to free itself from the law it creates or change the law. For these reasons, Hobbes said that he who is bound to himself only is not bound. The modern answer to this puzzle is to create an institutionalized separation of powers under which independent courts hold other government officials and everyone else to the law. Okay, so those are just the general shared views of the rule of law. I don't know any legal theorists that would disagree with anything that I've stated. Now let me begin with the first first point I'd like to make, and that is about emphasizing the fundamental importance of truth. And to do so, I need to go back to the election night 2020. President Trump addressed the country at 2:21 a.m. stating, "This is a fraud in the American public. This is an embarrassment to our country. We're getting ready to win this election," the president said. Frankly, we did win this election. We did win this election. Nearly 5 years have passed since the election, and Trump continues to insist that he won the 2020 election in defiance of overwhelming evidence to the contrary. The congressional committee that examined events surrounding the assault on the Capitol labeled this the big lie. Using testimony from Trump's own campaign staff and legal counsel, the Attorney General, and other state and federal Republican officials, the committee revealed that Trump was repeatedly told he had lost the election. Nonetheless, he refused to accept this. Attorney General William Barr directed the DOJ and the FBI to investigate all charges of election fraud, and they were found to be baseless. Barr later testified that, quote, "Americans were being deceived into thinking that there was this systematic corruption in the system, that their votes didn't count, and that these machines controlled by someone else were actually determining it," which is complete nonsense. Barr conveyed this message directly to the president in weeks following the election. Nonetheless, President Trump repeated the allegations of voting fraud on Fox News, and notably, he also implicated potentially the FBI and the DOJ. "This is total fraud," Trump stated, "and how the FBI and Department of Justice, I don't know, maybe they're involved, but how people are getting away with this stuff is unbelievable. The election was rigged. The election was a total fraud." 2 days later, Attorney General Barr told an AP reporter, "To date, we've not seen fraud on a scale that could have affected a different outcome in the election." President Trump was furious at Attorney General Barr, and he resigned a few days later. When explaining his resignation, Attorney General Barr stated, "And in that context, I made it clear I did not agree with the idea of saying that the election was stolen and putting out this stuff, which I told the president was bullshit. And, you know, I don't want to be a part of it, and that's one of the reasons that went into me deciding to leave when I did." Now, let me jump ahead and say that in the immediate aftermath of the election, many judges, there were 62 cases filed, all of the cases except for one, the Trump campaign lost, and the one in which it did not lose didn't affect the result. Multiple judges concluded that the allegations were not supported by the evidence. And I'll just give you judges from Pennsylvania. A federal judge appointed by President Trump himself, for example, dismissed a case filed in Pennsylvania, observing that the Trump campaign had presented, quote, "strained legal arguments without merit and speculative accusations unpled in the operative complaint and unsupported by the evidence." The appellate court decision upholding this dismissal, written by another Trump judicial appointee, stated, quote, "calling an election unfair does not make it so. Charges require specific allegations and then proof. We have neither of that here." In all, 22 federal judges appointed by Republican presidents were involved in these rulings. President Trump's lawyer, Sidney Powell, explained these sweeping losses in court by asserting, quote, "the judges are corrupt." As this account shows, one of the consequences of the big lie is that the election was stolen was to spawn secondary lies that support it. The claims that the FBI and DOJ, the so-called deep state, were facilitating the election fraud and that the judges who ruled against Trump were corrupt had no basis in fact. The Stop the Steal narrative, as everyone knows, was the campaign rally set up by Trump campaign. I won't go through the events that occurred on the invasion of the Capitol. I just will say this, that in the aftermath of this shocking incursion, President Trump repeated yet another false claim with no supportive evidence, that the assault on the Capitol was an inside job set up by unnamed law enforcement officials to to entrap Trump and his supporters. He reposted a tweet stating in all caps, "January 6th will go down in history as the day the government staged a riot to cover up the fact that they certified a fraudulent election." Let me just quote a letter written by a lifelong Republican, extremely conservative Judge Michael Liddick of the Fourth Circuit Court of Appeals. A week before the November 2024 election, he stated, "Yet to this day, the former president, his running mate, Senator J.D. Vance, and much of the Republican Party persist in the fraudulent claim that the 2020 election was stolen from them, and in breathtaking defiance of American democracy and the Constitution, that they can be trusted to ensure a peaceful transfer of power only if Donald Trump wins. That is not democracy and the rule of law. That is lawlessness." On January 20th, the very first day he resumed office, Trump commuted the sentences of 14 defendants who had been convicted of seditious conspiracy in connection with January 6th and fully pardoned all other individuals convicted or charged with offenses tied to January 6th. Over 1,500 people were pardoned, including 175 people charged with using a dangerous weapon or causing a serious injury to an officer, and all pending investigations were dropped. In justification of the pardons, President Trump cited the false narrative to justify. This proclamation ends a grave national injustice that has been perpetrated upon the American people over the last 4 years. Okay, so now let me talk about the ongoing consequences of this narrative. The narrative has justified a number of very serious actions being taken by the Trump administration. 2 months after returning to office, he gave a speech at the Department of Justice in which he aired his grievances and said that people will be held responsible for the lies and abuses that have occurred within these walls. Quote, "Our predecessors turned the Department of Justice into the Department of Injustice." He continued, "So now, as the chief law enforcement officer in our country, I'll insist upon and demand full and complete accountability for the wrongs and abuses that have occurred." Under this false narrative, Trump is restoring justice and the rule of law by investigating the investigators and freeing January 6 defendants. He claims to be ending the weaponization of the DOJ, not using the DOJ to vindicate his personal grievances. There's a warped reality that's created by the false narrative. And some of the consequences, as I said, are playing out now, and I'm just going to mention one. The Justice Department fired dozens of prosecutors who handled January 6 cases and investigated FBI agents who worked on the cases. Given the fact that the election was not stolen, these acts are obvious acts of retaliation. 3 high-ranking FBI officials, including a former acting director, filed lawsuit for wrongful dismissal. They asserted that in a conversation with FBI Director Kash Patel, he stated, quote, his own job depended on the removal of the agents who worked on the cases against the president, regardless of whether the agents chose to work on these cases or not. Now let me talk about the rule of law consequences of this narrative. The rule of law cannot function properly when government officials refuse to acknowledge facts supported by the overwhelming evidence while adopting false accounts of what occurred and using those false accounts to justify government actions. A false narrative has the capacity to transform a legitimate use of law into injustice and an illegitimate use of law into justice. This lesson has been overlooked and taken for granted, frankly, because no one ever imagined a situation like this would occur. We have not previously witnessed an untruth of such enormous magnitude maintained so doggedly by a president and his supporters. The rule of law simply cannot function properly when a cluster of lies become a predicate for government policy and action. Courts routinely accord executive departments officials, and this is a very critical thing about how our systems function, courts routinely accord them a presumption of regularity, the idea that government officials are conducting themselves in an ordinary, responsible fashion. A recent article stated, quote, courts have traditionally assumed public officials and the Department of Justice in particular are acting honestly, lawfully, and in good faith. Okay, now I'll talk about some of the consequences that follow from such an assumption when those circumstances do not hold. Let me move to that second point I was going to make, and that is about pretextual claims. Multiple actions by the Trump administration have been justified through pretextual claims based on facts in the law. Pretextual claims gain added effectiveness when courts reviewing the actions accord a degree of deference to their claims, particularly claims that involve foreign affairs and national security. Now, I'm going to run through a series of them, but I can't cover all of them because of the timing, so I'm going to just focus on a few. The first one is about targeting big law, people who are in law school and trying to get jobs. This might be interesting to you. President Trump issued executive orders that attacked a number of elite law firms, including Paul Weiss, Perkins Coie, Jenner & Block, Sussman Godfrey. He took quite serious actions, canceled security clearances for the lawyers, terminated their contracts with the government, barred lawyers' access to federal courts, among other sanctions. These punitive sanctions would disable the lawyers from serving their clients and financially devastate the firms. Several of the law firms, along with several firms that feared they would be targeted, entered agreements with the Trump administration that collectively promised to provide $1 billion in pro bono services. Trump told reporters that he thought the pro bono work could be used toward administrative work or even represent him in his own personal capacity. Brad Karp, the chairman of Paul Weiss, explained that he settled with the administration because the executive order, quote, could easily have destroyed our firm. The targeted firms lost business immediately as a consequence of the orders, and other law firms succumbing to the intimidation have chosen to avoid high-profile pro bono cases out of fear of angering the president. I won't run through all of the content of the executive orders. There were claims made in the executive orders that one firm is undermining democratic elections, the integrity of courts, law enforcement, and so forth. The one thing that all the law firms shared is that law firms targeted by the executive order shared is that they had represented prominent Democrats or had engaged in cases that went against the Trump personally or against the administration. Sorry. Now, in contrast to the firms that settled, 4 law firms challenged the executive orders in court, and all 4 firms that challenged it prevailed. The courts, deciding in favor of the law firms, concluded, among other grounds, that the orders violated free speech, due process, equal protection rights of the law firm, as well as the client's rights to counsel, and specifically that his actions lacked any legal authorization. The grounds provided in the executive orders were pretextual in that the reasons provided were vague, and the assertions that the firms were undermining democracy and the legal system were not backed by factual evidence. One of the judges presiding over the case, Judge Ali Khan, stated the order was one in a series attacking firms that had taken positions against which Trump had disagreed. When justifying the executive actions against the firms, Trump himself stated, quote, the firms did bad things and attacked him ruthlessly, violently, and illegally. District Judge Burl Howell, presiding over Perkins Coie challenge, quoted multiple instances of President Trump directly threatening Perkins Coie prior to the election. Here's one quote. I was innocent on all counts. If I'm elected, he's speaking about Perkins Coie now, if I'm elected, they will be brought to justice, something that the Republican Party has always been afraid to do. Judge Howell remarked, these retaliatory threats have now come to fruition. Judge Howell asserted, settling personal vendettas by targeting a disliked business or individual for punitive government action is not a legitimate use of the powers of the U.S. government or an American president. On the final page of the opinion, Judge Howell stated, and these are rule of law, specifically rule of law concerns, government officials may not, quote, engage in a use of purely personal and arbitrary power. Judge Ali Khan, presiding over the Sussman Godfrey case, raised 2 additional fundamental rule of law concerns. One is that, I already mentioned, the Trump administration pointed to no statutory authority that allowed these actions to be taken. But the other one is even more important in my view. The second concern raised by Judge Ali Khan is that, quote, the order threatens the independence of the bar, a necessity for the rule of law. In order to hold government officials accountable to the law, the rule of law requires that lawyers be willing to represent clients without fear of retaliation from government officials. I have another extensive section on the universities. I'm going to pass on that, but I'll just suggest to you that the pattern of actions was the same. A group of elite universities were targeted. They were threatened with a series of actions that were potentially devastating. Let me just pick up on Harvard. The only school to fight these charges was Harvard. As soon as they fought the charges, the federal government halted $2.2 billion in multi-year grants, research grants, things of that nature to Harvard. President Trump then said, quote, we're going to take away Harvard's tax-exempt status. And then he further announced that the university would conduct a comprehensive view of all Harvard patents on inventions. They also threatened to not allow any student visas for people to study at Harvard. The judge presiding over the case, Judge Allison Burrow, observed, "These actions were arbitrary and at worst pretextual." Burrow's remark, "A review of the administrative record makes it difficult to conclude anything other than defendants were using a smokescreen for a targeted, ideological, motivated assault on this country's premier universities." In response to the ruling, the editorial board of the Wall Street Journal opined that the Trump administration's, quote, brass-knuckle tactics are doing damage to the rule of law and the First Amendment. Now let me talk briefly about the tariffs. As many of you will know, he imposed substantial tariffs on goods imported from around the world. The problem with this is that Article 1 of the Constitution grants Congress the power to lay and collect taxes, duties, imports, and excises, as well as to regulate commerce with foreign nations. Despite lacking any explicit legal authority to impose these tariffs, the Trump administration invoked the International Emergency Economic Powers Act of 1977, EPA, to support its actions. The problem is, by its own term, so EPA authorizes presidents to take certain actions in response to unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. The problem is that EPA does not use tariffs or duties or customs or taxes anywhere in its language. And furthermore, no previous president has invoked EPA to impose tariffs or adjust rates. President Trump declared various reasons for it, but finally in April, including bringing drugs across the border, China, Mexico, and Canada. But finally, in April, the justification for a 10% tariff imposed on every country and then 11 to 50% ranging depending on the country. The declaration of emergency specifically claimed was, quote, an unusual and extraordinary threat to the national security of the economy follows from a lack of reciprocity in our bilateral U.S. trading partners through their economic policies. In other words, President Trump claimed that the trade deficit itself is an extraordinary threat. Now, let me just cite the remark of conservative legal scholar Ilya Somin, who pointed out that a congressional report preceding the enactment of EPA specified that it was based on the understanding that, quote, emergencies are by their nature rare and brief and are not to be equated with normal ongoing problems. A Federal Circuit Court of Appeals decision recently came down 9-4, holding that the tariffs were unlawful. And the basic reason is the reason that Somin suggested, that ultimately tariffs are that the current economic situation is an ongoing situation. The EPA is only for emergencies, and as the court pointed out, EPA is supposed to exist, the actions are supposed to exist only so long as the emergency exists, but the tariffs are, quote, unbounded in scope, amount, and duration. Okay. Let me quickly talk about the summary. I'm sorry, can you tell me how much time I have? You're 12:30. 12:30, okay. Now I have to speak even more quickly and cut out even more. I just want to quickly talk about summary deportations under the Alien Enemies Act, the AEA. It authorizes the president to apprehend, detain, and deport people from a hostile nation in a declared war, quote, declared war, or, quote, invasion or predatory incursion. This act has been invoked only 3 times, once during the War of 1812, once during the First World War, and once during the Second World War. There's no declared war with Venezuela, as you all know, but the Trump administration claimed that the Maduro regime is directing the gang, TDA, so it's carrying out an incursion on behalf of a hostile nation. In a 2-to-1 decision against the administration in the Fifth Circuit, the majority observed that proclaiming without more than an invasion or predatory incursion has occurred does not suffice. What is an invasion is a legal interpretation, and based on the original understanding of those terms, this does not qualify. What I want to focus on instead is the dissent. The dissent was written by Judge Andrew Oldham, who is often said to be on a short list to become on the Supreme Court. Judge Oldham vehemently disagreed, arguing that President Trump's decisions on both the facts and law are unreviewable. That is, quote, the president has zero obligation to produce findings of fact to us to defend his conclusion that an actual or threatened war or invasion exists. This is again quoting Judge Oldham, determining whether the AEA's conditions are satisfied depends on matters of political judgment for which judges have neither technical competence nor official responsibility. He went on to argue that, again I'm quoting, while the president must follow the law, That obligation on the part of the president in no way implies any authority on the part of courts to enforce that obligation. He pointed out that the president takes an oath to abide by the law, and the White House and DOJ officials take an oath to follow the law. So his legal advisors can restrain the president when his actions are contrary to the law. Thus, Oldman asserted, quote, "Make no mistake, executive branch officials, including the president, are subject to the law." He continued, "But that does not mean unelected, unaccountable federal judges have the power to do anything about it in any particular case." Now, Oldman's total denial of judicial oversight of executive actions in these types of cases strikes directly at the rule of law institutional arrangement that places judge as the final guarantor of compliance with law by government officials. To accept that would leave the president a law unto himself. Moreover, Oldman's assertion that his White House and DOJ legal advisors might disagree with the president is belied by the facts. Harvard law professor Jack Goldsmith, a highly respected conservative scholar who worked in the Office of Legal Counsel for the Bush administration, recently commented at a conference, quote, "An atomic bomb has dropped on the apartment." Goldsmith said, and again, this is a full quote, "There are tens of thousands of lawyers in the massive executive branch spread out whose job is to ascertain the massive arrays of laws that are supposed to govern executive branch behavior. And you can be cynical about the system, but it's always worked, including with the Justice Department, in keeping the White House and senior executive agencies more or less within the law, with some exceptions. And this administration has systematically and ruthlessly and successfully eliminated, with one exception, all internal resistance. It is simply not acceptable," Goldsmith said, "to offer an opinion contrary to the one that the president, who is not a lawyer, wants to push. It's really an extraordinary thing." A critical rule of law lesson lies in the juxtaposition of Oldman's and Goldsmith's observations. The reality is that innumerable decisions are made daily by government lawyers that keep government officials within the law. Since judges review only a fraction of this, compliance with the law in the first instance and in the overwhelming majority of instances depends heavily on the good faith determinations by lawyers of what the facts and the law require. But restraint through lawyers, which Oldman uses to assure us that President Trump is legally bound, breaks down when government lawyers are not free to oppose what the president wants, and that is precisely the situation within the Trump administration described by Goldsmith. I will skip a lot. It was really good. Just imagine it. Very convincing. What I'm passing over is a series of similar pretextual arguments and judges, and when the essay comes out, you can read it there. Let me shift to the third point. The third point is about flooding the field with unprecedented actions and using time to its advantage. In a short period of time, the Trump administration has taken unprecedented actions across the entire range of government activities with questionable factual and legal support, flooding the field with acts to press against the outer limits of legality, and it has used time to its advantage. To repeat some of what I've just said, no president's ever attacked law firms or universities, ever invoked EPA to impose tariffs, ever invoked the Aliens Enemy Act against drug gangs, remove union rights from a huge swath of government employees. Let me just say something quickly about union rights. President declared a bunch of administrative agencies involved national security and then took away their union rights. It affected almost 1 million people. Some of the people that lost their union rights for national security reasons were secretaries, cafeterias, janitorial staff, Department of Education, in all of these branches that apparently have nothing to do with national security. The court in that case said, we don't feel comfortable questioning that national security ground, so I'll come back to that later. The point is, let me just list a few more that I wasn't able to go to. President Trump's terminated without cause members of the National Labor Relations Board and the Merit Systems Protection Board, despite the fact that the statutes that create these agencies have statutory protections against firing. He deployed 4,000 National Guard troops and 700 Marines in Los Angeles, which was recently determined by a court to contravene the Posse Comitatus Act. Contrary to the Impoundment Control Act of 1974, he's refused to spend billions of dollars in foreign aid authorized by Congress, effectively shutting down USAID, and withheld billions from the Department of Justice. The Department of Government Efficiency fired tens of thousands of civil servants without cause. Here's the problem. The sheer quantity and novelty of these actions, combined with the magnitude of the states, poses a serious challenge to the routine operation of the judiciary. Although the numbers are constantly changing, by the end of July, over 337 lawsuits have been filed against the Trump administration. In 165 of these lawsuits, the courts ruled against the administration. Now, judges generally take a deferential stance towards presidents, so that's an unusually large number of losses. Trump and his supporters castigate judges who rule against them as corrupt or biased, but a more plausible explanation is that his numerous unprecedented actions push beyond what the facts and law allow. The other factor playing out in this situation is time. The administration can swiftly take action simply by claiming it has the authority and then executing it. Courts, however, move very slowly by comparison, holding hearings, considering legal briefs from interested parties, drafting reasoned, often lengthy decisions. Since in many instances the executive branch's actions being challenged have already taken place, the administration has effectively altered the situation on the ground before courts have made their ruling. For example, as I already mentioned, the administration's already collected billions in tariffs, and it would be financially very difficult logistically to return the money, making it all the harder for courts to rule against them. The administration's attacks on law firms and universities extracted $1 billion in settlements from firms and hundreds of millions from universities, and more importantly, or just as importantly, intimidated other firms and universities to bend to its will, before rulings finally came down saying that the administration could not do this. Let me mention one last example in time, and this decision just came down 2 days ago. Early in the administration, DOJ, Officer of Personnel Management working with DOJ, directed the firing of all probationary employees. Judge William Alsep, the decision was handed down a couple of days ago, said that this was contrary to the law. In fact, he explicitly cites pretextual arguments in that case, but this is what he said. He did not direct the government to rehire those employees because, quote, too much water has passed under the bridge. The agencies have moved on. Many of the probationers have no post to return to. This is fait accompli. The clear message in this is that the Trump administration can do and should do what it wants to, even if of dubious legality, and keep moving forward. By the time the courts catch up to rule the actions illegal, the administration would have already achieved its goal. The lesson this reveals is that the rule of law can be circumvented by taking a multitude of factually and legally dubious actions at one time, hitting hard and fast, and keep moving, staying ahead of the deliberate, plotting courts. The final piece that must be mentioned is a clear pattern of attacks on judges and defiance of their rulings. President Trump and members of his administration routinely attack judges who rule against him as corrupt partisans. These sharp criticisms of judges have coincided with increasing numbers of violent threats against individual judges. Stunningly, I won't mention all of them, but I want to focus on one. The administration took the unprecedented step of suing all of the federal district judges in Maryland over their negative treatments of Trump's deportation orders. They sued all of the judges, the administration. That has never been done before. Judge Michael Ludwig called the suit reckless and irresponsible and yet another frontal attack on the federal courts of the country. What I want to focus on is the opinion by Judge Thomas Cullen, who presided over the case and then ultimately dismissed it. He issued this sharp admonishment. Indeed, over the past several months, principal officers of the executive and their spokespersons have described federal district judges across the country as left-wing, liberal, activist, politically minded, rogue, unhinged, outrageous, overzealous, unconstitutional, crooked, and worse. Although some tension between the coordinated branches of government is a hallmark of our constitutional system, this concerted effort by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate. Let me emphasize that Judge Cullen, who made these critical remarks, was a Trump judicial appointee. In addition to attacking judges, the Trump administration is engaged in conduct that skirts with defiance of judicial rulings. Again, let me leave out the specific details, but I do want to cite an important whistleblower suit filed by Erez Ruvani, a former high-ranking official in the Immigration Litigation Office in the DOJ. He specifically details instances in which DOJ officials ignored court orders, presented legal arguments with no basis in law, misrepresented facts to the courts, and directed him to misrepresent facts to the courts. And Ruvani refused to do this and was fired as a consequence. Now, a hugely problematic aspect of this situation, which is also unprecedented, involves the Supreme Court's string of summary decisions with scant explanations. Since taking office, when the Trump administration sought emergency orders from the Supreme Court to block lower court rulings, called shadow docket cases, the Trump administration has thus far prevailed 18 times and lost only twice. These decisions are made quickly and without hearings. The problem is not just that the Supreme Court has overwhelmingly ruled in favor of the Trump administration, which raises questions about whether the court is favoring the administration. By comparison, I should mention, in similar cases, the court ruled for President Biden 10 times and against him 9 times. But a more problematic aspect of these decisions is that nearly all of them are declared with little or no explanation. An extraordinary interview was published by NBC News recently, in which they interviewed 12 judges anonymously, 12 federal judges. I'll just point out 2 things that they focused on. The first thing, and they were objecting specifically to the shadow docket decisions, the first problem is that they provide little guidance to the courts. Here's a quote from one of the judges. Judges in the trenches need and deserve well-reasoned, bright-line guidance. That's what the rule of law requires. We need to know what the law requires. Quote, the judge says, too often today, sweeping rulings come from the Supreme Court with breathtaking speed but minimal explanation, stripped of rigor that full briefing and argument provide. But the second exception is also important. This was raised by a majority of the judges. They objected that these short reversals with little explanation, sometimes reversing 100-page decisions by the district judge, quote, makes it seem like they, the lower court judges, did shoddy work and are biased against Trump. Here's a quote from one of the judges. The Supreme Court, a judge said, is effectively assisting the Trump administration in undermining the lower courts, leaving district and appeals courts judges thrown under the bus. The rule of law cannot function properly if the apex court issues rulings with little more than a thumbs up and thumbs down. Indeed, in a recent case, the Supreme Court itself found, and this is when examining the actions of an administrative agency, quote, an agency action qualifies as arbitrary or capricious if it's not reasonable and reasonably explained. The same can be said of a Supreme Court ruling that is not reasonably explained. In closing, I want to get to the heart of what all of this tells us, or at least me as a theorist about the rule of law. It turns out that a fundamental requirement for a functioning rule of law system is that every lawyer, particularly those holding government positions, in every instance make good faith determinations that the facts and the law support the positions they're taking. The entire legal system operates based on this assumption. This is particularly necessary when many government decisions and actions are unreviewable owing to time or subject matter. Every lawyer who enters the bar and every lawyer who enters government service takes an oath to comply with the law and the Constitution, and the rule of law depends on lawyers keeping this oath. Thank you. I guess we have time for questions? Sure. I wanted to save time for questions. That's why.
Oh, yep. We have a mic coming around.
Oh. Yeah, two broad observations I would be interested in your comment on.
Yeah.
I understand institutionally there is an answer when the executive branch overreaches, engages in an assault on truth, uses pretext. The institutional answer is the judiciary is there if they choose to act.
Yes.
Although you do have the impediment of time, which I think is a very good observation. But there is an institutional answer. That is, the judiciary is there. The larger problem, however, that we have today is that if the judiciary itself lacks credibility in the eyes of the citizenry, then you have a real problem with the enduring nature of the rule of law. If people don't believe in the result that the judiciary has announced, we have no institutional answer for that. Second observation, the judiciary has, unfortunately, a very limited capacity to enforce its orders if push comes to shove. Witness the departing plane, arguably in defiance of a court order, arguably intentionally defiant. you know, we approach a real crisis point if we get to the stage where there is an order, Supreme Court, appellate court, district court even, where there is outright defiance, unapologetic defiance of a court order, recognizing that all the judiciary has at its disposal is a very limited U.S. Marshal Service. That's a real crisis point if the rule of law cannot be enforced.
Well, I agree with absolutely everything you said. I just want to point out a couple things, and a part of this was left out because I skipped over it, but one of the things I wanted to emphasize is this assumption of regularity, and that provides deference in which courts, just as a routine matter, just assume that the administration is acting in good faith. And so if you have that assumption and then therefore defer, and then here's the critical point, as a result of the deference, you don't examine the decision itself for correctness. And that's some of the stuff I left out. This is particularly on national security grounds. The court just doesn't feel capable of getting into that. So it's that routine operation and the routine deference that can be utilized, and let me just speak abstractly, by a bad faith actor to get a lot of things done. In terms of the problem with public belief in the courts, I totally agree with you. In fact, that's another theme here. But the problem is, where is that impression coming from? Is it because the courts are corrupt or because they keep being called corrupt? Every time a decision is made against them, they're called corrupt. You can't sustain that. But this is Judge Cullen, a Trump appointee, saying that himself. We just can't function this way. And as you pointed out, they have no ability to enforce. I want to say about the defiance, and the critical word you said is open defiance. I think that's going to take us to a very bad place. But right now, there's defiance, but not open. And this was playing out in the deportation rulings. It's in Ruvani's, in his whistleblowing complaint, he talks about, he was told to defy court orders. In fact, by someone who was recently appointed to the federal appellate court, Bove.
Thanks for this. It's been terrifically interesting and thought-provoking. I wonder, and I completely agree with your conclusion that the rule of law depends upon all lawyers. So what about law professors? What, if anything, do you think the current pressure on the rule of law that you've identified so clearly, how does that affect the role of law professors? Are there actions that law professors should be taking, things we should be saying or doing to uphold the rule of law?
That is a very difficult question. And we're in a different position, I think. Our duty, in my view, is to teach our students. And teaching students, in my view, involves teaching them, providing them information. That information, some of it can reflect poorly on the law. Some of it reflects poorly on judges. But others of it shows the importance of law. In my view, it's their exposure to all of it that they learn from this process. With respect to any given professor, I think our normative obligations are the truth. That's my view. Beyond that, I think it's a decision that each of us has to make, but that I would stay with. And in that sense, I think this is parallel to the obligation that lawyers have. We have an obligation to truth.
Thanks for doing the lecture and for a tour de force, even if you had to cut a lot out. I want to come back to the question before. You started this premise with rule of law is built as a check against arbitrary authoritarianism, right? And that Madison thought, hey, the separation of powers is the effective way. But then you've made this really interesting point that it seems like you're saying the rule of law is also dependent on good faith action by the executive. But that seems to be in tension, right? Because, so are we saying really that rule of law, is Hobbes right, that the rule of law is not really possible check because the separation of powers doesn't work if you have a bad faith executive. In theory, the whole point is that you've separated the powers to check a bad faith executive, right? And normally what we've had in normal times is the occasional misstepping or accidental bad faith.
Right.
But is your take that like it's not rule of law is not robust enough in the face of willful misconduct from like at scale from an executive?
If the what I'm saying is, let's say I were to abstractly, systematically across the board challenge accepted legal positions on everything I can, just to get through whatever agenda I want. I don't believe just that the system can handle this easily because it operates with a different set of assumptions. And that set of assumptions is that the lawyers will be making good faith determinations of what the facts support and what the law supports. But the agenda that I gave doesn't care about that. At that point, I would just simply make pretextual arguments and then go through and see what I win. And meanwhile, even if I lose, it doesn't matter because the taking of the action itself has all these consequences that I wanted have already occurred, so I don't care. I believe that this is a way of systematically undermining the rule of law. And frankly, I believe that's what we're seeing. Now, I'm not saying the rule of law has collapsed at all. I want to emphasize, a lot of courts have ruled against them. And that's where things seem to be holding up. Now, some of these decisions might be wrong. Almost everything, here's another example of the time thing, as I mentioned. These actions were taken months ago when they first came in. Only now are decisions coming out. I've been working on this speech for the last 3 weeks. Oh, here comes a new opinion. I'm working it into the speech. There's another one. But that tells you that 3-4 months, things have already changed. Universities across the country have altered their conduct. So have major law firms. So I guess in answer to your question, I would say that what this shows us is how much the good faith component matters, the good faith part, right? Every lawyer who signs a brief, you're asserting that you have a factual predicate, and this is a good faith argument. So we built it into law in all sorts of places. If that's not being complied with, I do not believe any system can hold up to it. And I think we're seeing the kind of edges beginning to crack here. Now, one thing I want to leave open is the Supreme Court. I don't know what they're going to do. And I'm not even saying right now that they're doing anything bad. They issued a lot of emergency docket rulings simply because so many of these cases have come up. That's why. So I can even say to them, I feel a little sympathetic. They're getting inundated with all of these decisions that are striking actions. They have to do something. That's now. Now we will see as this plays out in the coming year. As instead of unexplained decisions, we now see full explanations. And it may be some they support the Trump administration, some they go against, but we have to see. So I'm open-minded about that. I'm just saying what we're seeing in real time is that the system is being pressured and pushed back and back and back, and everything on the ground is changing as a result. And that's happening. So I don't know what to say beyond that, except this has never been seen before, at least in our system.
Go. Yeah. I'm gonna take ask my question. So first of all, thank you so much. And for those of you who want to read the full length of his remarks, it will be published in our law review. So that'll be great. So I just my question is kind of following up on what you just said, which is I think you quoted so many conservative judges, right, that are actually proving that there is still some resistance, there is still something operating. And I think that makes it really challenging to know how to talk about this, especially with students, but just in general, because there's this fear, I think, that if you oversell, you don't want to downplay what's happening right now, but you also don't want to oversell it to the point where it almost sounds like there's no checks operating in the system when there still might be. And the worst case scenario in that situation is you're almost giving more power to the administration to as if there is nothing left that's kind of operating as a check. So I just am curious about how you think about that really tough balance between wanting to kind of explain that this is a unprecedented moment, but
also to kind of explain how there is still some pushback in the system that is operating.
Right, this is partly what I was answering in response to your question. I think our obligation, so let me elaborate on what I said where our obligation is to the truth. Where I would violate that obligation if I said only the bad stuff, Trump this, Trump that, bad, and a lot of this sounded like it, but I'm setting up a discussion of the general scenario. It's also my obligation, I think, to talk about areas where, okay, maybe they were right, or the courts were doing the right thing. Some of this, and again, this is partly because this is happening real time, some of this we have to wait and see. So I can't go beyond saying, look, I can say this for sure right now. He did many boundary pushing, stretching positions. To fire members of the boards in which their own statutory authorization requires protections, but without complying, is a boundary stretching move. That's a blatant, I will do this. To not spend money that's been allocated by Congress, that's a boundary stretching move. Now, it may turn out that the Supreme Court changes the law and goes with this. So that boundary stretching move will have succeeded. But as a legal determination, because the Supreme Court says, well, for this reason, our prior decisions on this matter were incorrect and we overturn. So how this plays out, we need several more steps to come, is what I'm trying to say. And my obligation is to acknowledge all of that. But beyond acknowledging all of that, I think we have another critical responsibility, and that is not to use a journalistic phrase, not to both sides everything. There's no both sides on everything. This is what's happening, and this is what's happened in the past, and this is what's happening going forward, and giving proportionality to it, talking about. As I said, I've been studying the rule of law for over 20 years, but also I study history. I don't know, we've had bad times in our country before, everyone. Let me just say that. Civil rights protests was a very difficult era. Anti-war protests was a very difficult era. Students were shot. Okay, we're not there. We can keep perspective. But having said that, I can't think of another, I don't want to say, I'll put it this way, I can't think of another across-the-board challenge to the rule of law at all that I remember ever seeing. And I think it's my obligation to say that. Why? Well, because students won't know that. They're not the ones who have the history, who've studied the past, who know about how things work. So that's a part of what I feel my obligation is.
Okay, I'll be quick. Thank you so much. It's been such a pleasure to have you come, and we really appreciate it. And students were riveted. They were absolutely riveted for the period of time that they were here. And I ran over from the business school class. So yes, we absolutely want to hear you. Thank you. This follows up, though, on John's question, Adil's question, Gur's question. And it comes to a more uncomfortable idea, and I just want to wrestle with this with you for a minute. Maybe the features of the rule of law are internally inconsistent. Remember, Tom Tyler wrote the book, Why People Obey the Law, and he came to the conclusion that people obey the law because they believe in procedural justice, that procedural justice is the core, fundamental, motivating factor for all of those compliance officers, the regulatory counsel, the agency counsel, all the people you're talking about who have to have good faith interpretations at every point, right? They've got to believe that there's procedural justice. And Tom Tyler, in his experimental work, right, literally found that this is belief in the impartiality of process and transparency. But doesn't that create the very problem that you're talking about? Because number one, you don't like the shadow docket, right? There's not transparency there. But that's speed, right? Is it just true that the rule of law never has speed, or our rule of law based on procedural justice can't have speed? But then, and then you say, well, if we get full explanations, but what if those explanations all show the correct procedure, but the outcomes are all in one direction, which is another thing that you suggested, right? Like the outcomes against the universities and other countries and tariffs and unions. You mentioned that all these outcomes were coming out disproportionately in one direction. So there's another problem with this. And then there's something else going on that does seem to be a problem, which is that the rule of law is at least supposed to be procedural just, therefore it's supposed to be slow, therefore it's supposed to be transparent. But isn't there another problem here in that if you go ahead and you create speed and lack of transparency and all the other things, the last problem that you have is that somebody like Trump, or in Trump's mold, who is the ultimate rule breaker and pushes the system, shows the breakdown of the system. It isn't the whole point of rule of law to catch the outlier. In other words, because we've created something that's slow, that we have to believe is transparent, that we have to trust in the outcome because we need this, doesn't it exactly defeat what we also talk about the rule of law in being able to do, which is to catch the outliers who have accumulated resources and have speed and have outcome and have all these other pieces? I'm just wondering about that tension. Can you have rule of law that is ever fast enough to catch this, ever procedurally just, and still can give you robust outcomes when you move fast and you do all the things that you've been describing?
I think sometimes you raise very important points, none of which I disagree with. Sometimes I think we ask too much of the rule of law. I mean, rule of law is an ideal, right? The rule of law can't save us from ourselves. I mean, we're the ones that give rise to the system. And part of the problem, which you touched on, is that it doesn't work in lots of contexts. You know the state of exception, right? I mean, society is not always functioning in an orderly way. Laws presupposes functioning in an orderly way. Martial law, things happen where we put on pause. And part of that's playing out in this context because so many, I will just tell you now, that given the amount of deference that courts have expressed towards national security determinations, going forward, though, that will continually be the grounds for every action taken, wherever that can be cited. In fact, they're already doing it. So, but the reason I raise that is because here we have a bunch of rules, but then we get to this category, national exception, hands off. All right, now that exists for different reasons. But what that's telling us is there's some big places in the system where we say, let's pause on the rule of law right now for here. And I think we're seeing examples of that appearing. So some of it is by declaration and purposeful placing in category to avoid it, but some of it is because it's true. There are situations where things have to proceed in a much faster way that the ploddingness of courts and law doesn't work for. The ploddingness of procedural justice. Procedural justice requires hearings. The China docket cases don't involve hearings. I mean, so you can create an emergency and then utilize it for your benefit. You can claim an emergency and utilize it to achieve what you want. I think we're seeing versions of all of this being played out right now. And I don't think the system, as it normally functions, can manage this easily. And there are consequences, and we're watching them play out right now.
Join me and thank you, Mr.
Thank you. Okay, thanks. I know I still talked.